Hello, welcome again to our further discussions of the Rekieta saga, or the Rekieta question, the RQ. There have been some filings. There's been some filings that I think are worth going over. We got a great criminal defense topic to talk about tonight. The prosecution's response to a motion to suppress, motion in limine, and a Frank's motion. You know, they put a response together, and the way I showed it, that's a JDAM coming for the Baldo bunker. I hope that kind of tips your hand at what I'm thinking here. Is this a home run and pack your bags? No, but this is devastating. This is devastating. I would not be happy if I was Nick right now. I can tell you that much. Yes, Mr. President, the second Baldo tower has been hit. The second Baldo tower has been hit, Mr. Rekieta. Oh, so here we go. So the prosecution had until today. So Nick had filed his Frank's motion where he's alleging that the state lied and they done everything. Basically, they lied. Detective Pomplin lied. Aaron wasn't reliable. That April's statements shouldn't be able to be used against Nick, which that's going to be a motion to eliminate issue. But yeah, I do. Like I said, I still think there's Sixth Amendment issues there. There's confrontation things. There might be hearsay exceptions that can be worked around with. Don't really know yet. Don't really know how that's going to play out because we're not even to that part yet. We got to deal with the warrant still. We're still on the warrant. So Nick and his attorney dropped the motion like 3 days before the hearing, which, like I said before, if that's what took you 2 months to bang out, woof, 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 woof. Part 1. The defendant is not entitled to a Frank's hearing and cannot go beyond the four corners of the search warrant in a probable cause challenge. So they agreed that no warrant shall issue without showing a probable cause. The Fourth Amendment in the Minnesota Constitution, Article 1, Section 10. To determine whether the judge had a substantial basis for finding probable cause, they looked to the totality of the circumstances. The task of the issuing judge or magistrate is simple: to make a practical, common sense decision whether, given all the circumstances set forth in the affidavit, including the veracity and basis of knowledge of persons supplying hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. Quoting Illinois v. Gates. Guys, in Illinois v. Gates is one of the big foundational cases when you're dealing with modern search warrants and how things are done. Gates really kind of was a watershed moment. There was a previous test, the Aguilar-Spinelli test, which is far more restrictive. And this is one of those times where the Supreme Court took out their scissors and they went snip, 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 snip to the Fourth Amendment. Okay. In reviewing the sufficiency of a search warrant affidavit under the totality of circumstances test, courts must be careful not to review each component of the affidavit in isolation. And that's a big point. You have to look at everything as a totality. Remember, guys, it's a wall, and you have bricks in the wall. You don't examine a single brick and say, well, the brick is bad, therefore the wall's bad. Does the wall stand? Does it stand up in the wind? Is it a strong wall? Or more importantly, you have a bunch of raindrops. You don't look at each drop of rain. You look and say, do I have a flood? Yes. Okay. You don't granularly inspect everything. And they say a collection of pieces of information that would not be substantial alone can combine to create sufficient probable cause. Yes. And you know how we could see that? It's like from Children's Services. All that information about what was going on in the home, it wasn't enough for Children's Services to do anything with. But when you combine it with all the information the police took in, they could combine to create more probable cause. It could strengthen it. And it says, furthermore, the resolution of doubtful or marginal cases should be largely determined by the preference to be accorded warrants. In determining whether probable cause exists, both the district court and the reviewing court may consider only information in the application for the search warrant. And yeah, you're kind of stuck with the affidavit. I mean, that makes sense. Whether there's probable cause to support the warrant is decided on the face of the warrant application and the information contained within the four corners of the document. So as they mean, guys, they mean literally like the four corners of the piece of paper. To go beyond the four corners of the search warrant, a defendant must establish a substantial preliminary showing the affidavit contains a false material statement, the affiant made the false statement intentionally or with reckless disregard for the truth, and 3, the statement is necessary to support a finding of probable cause. And this is US v. Swanson. It's from the 7th Circuit. You're generally better off citing like where you live. So you'd think they'd hit an 8th Circuit case instead of a 7th Circuit case, but whatever. Requirement of a substantial preliminary showing is not easily met. To make this showing, the defendant must make an offer of proof in the form of a sworn affidavit of a witness. They point out Franks. Remember, Franks v. Delaware, guys. Everybody cites Franks, but there's no actual citation for Franks in either document, and that kind of infuriates me. Franks is limited to cases of perjurious or recklessly false statements or omissions made by a police officer in support of a warrant. The rule does not apply to negligent misrepresentations or omissions. And this is, once again, another 8th Circuit case, which 8th Circuit is where Minnesota is, but it's not Minnesota law. So in this situation, is it persuasive authority? Yes. Is it controlling? No, it's not controlling. It's not binding authority. It's not precedential. But it is something that shows how federal courts interpret Franks, and Franks is a U.S. Supreme Court case. So it does give the court a little bit of, way to look at this. They say here, no affidavit was offered by the defendant, no testimony was offered by the defendant, or any defense witnesses. The only challenge of the search warrant comes for the defendant's omnibus motion alleging the misinformation or lack of information was provided by law enforcement in the search warrant. And that's true. There was no affidavit from Nick or anyone else. There was no testimony offered by Nick or anyone else. And remember, guys, as I said, just saying, us and Aaron don't get along and Aaron made some threats. Like, okay, but threats about what? What's the reason why Aaron hates you? Remember, part of this issue is, well, how is this a lie? How are things unreliable? What's reckless? How is it reckless? Just a conclusory allegation of, well, they lied or policeman bad isn't enough. You have to articulate it. You have to provide the court a chance to read it and understand, okay, yes, here's an affidavit saying here's what happened, or here's why I know this is bullshit. Or being able to flesh out a full argument. For example, the whole thing with Aaron. Nick would have to they would have to provide the information saying, Aaron and Nick, well, they, as his attorney said, well, they just don't like each other. Well, it's because they don't want to bring up the point of, well, Your Honor, Aaron and Nick, well, they were involved in this wife-swapping polycule, and, well, Nick started cornholing Aaron's wife, and they were all doing coke together, and Aaron decided he wanted to quit doing coke, and Aaron wasn't able to get April to leave the coke-fueled polycule, so he blames Nick for destroying his marriage. That would be how you establish bias and show it. But they didn't do any of that. And just like with Detective Pomplin, how do they know it's fake? How do they know it's false? Well, they just point out like, oh, well, here we're saying it is. But how? Based on what? How do you know? Compared to the original, how do we know? We haven't seen the original. Did Nick give an affidavit saying, this is not what it is? Or somebody else who could attest to it? No, we don't have any of that information. They point out that Nick did submit some exhibits in support of his motion. However, the exhibits are incomplete and create a misleading picture of the evidence provided. This is essentially a fishing expedition by the defendant to go beyond the four corners of the warrant. The defendant is attempting to get a Franks hearing without making the requisite showing. And I agree. This is fishing. They want to get him up there to try to find stuff. No, you have to show what you're going to find or you believe you'll find. You can't just go, this is sussy. And then the prosecutor brings up the Kaneohe County Children's Services letter. And they bring up that they screened out the initial maltreatment report, and that should not have ended the inquiry. They point out the search warrant wasn't based solely on the maltreatment report, and that the screening of child maltreatment reports is controlled by an entirely different set of statutes and standards than criminal cases. And as I tried to explain, the way they handle it is different than the way the police handle information. For children's services, they get calls all the time they have to screen out. So it wasn't as though it's unsubstantiated. It's something they just couldn't investigate. They didn't have enough to investigate. An unsubstantiated finding is an actual, like, serious finding. They don't just say, oh, we couldn't look into it, therefore it's substantiated. There's like, we declined to investigate it. And they say whether there's enough to investigate a child maltreatment report has no bearing on whether or not criminal activity may be occurring. And that's true. Remember, Children's Services, Alicia Sweep, they look at that brick and they're like, you know what? I can't build a wall with this. It's garbage. Well, Detective Pomflet can pick it up and say, actually, you know what? The brick's fine. I can use this brick and I'm going to put it in my wall. And guess what? It helped build the wall. Oh, put it on screen? Shit. Sorry, chat. The screening of the maltreatment report should have ended the inquiry, but that's not true. The screening is controlled by a different set of standards. The way Children's Services works is different than the Sheriff's Department. And the way Children's Services works doesn't have any bearing on how the police investigate. If Alicia Sweep says we can't do anything about it, Detective Pomplin can't go, I guess we're fucked too. No, that's not how it works. He's allowed to take that report they have and go, I can use this information, click into the wall. And it gives him more probable cause. Child maltreatment reports are cross-reported between law enforcement and child protection services. This is a state mandate. They have to work together. Once Pomplin received the report, he began an investigation of whether or not there was criminal activity related to drugs. The purpose of his inquiry is different and not controlled by CPS standards. Both agencies started with the same information, and they applied their standards to that information differently. It's not relevant that the report was screened out. And they argue, even for the sake of argument, if it was relevant, whether or not the child maltreatment report was screened out by an entirely different agency using different standards has no bearing on the probable cause determination. The report was the basis for the start of law enforcement's investigation. Remember, guys, when the pastor came to the police department and he told the sheriff what was going on, that's what started everything. Remember, that's the reporting by the pastor, that the prudest of the Scandinavians, the ringleader of the Scandinavian prudes, came to the sheriff and said, look, here's what's going on. The sheriff said, okay, cool, we'll take that information down. They gave it to the detective. The detective was going to start, I need to look at what the hell is this all about? So he started looking it up. And then he finds out about Aaron. Oh, okay. And then he finds the stream with Nick. Oh. And wow, this all kind of matches up like somebody on drugs. The same time Alicia Sweep is reading this and saying, well, I can't do anything about this yet. This isn't enough for me to actively move on. Okay. So two people can do different things. Now, it wasn't the sole basis for the search warrant either. And even if the court were to strike the information, there is still probable cause for the search warrant based on Pomplin's subsequent investigation. And I don't think it should be stricken. I think they have a valid reason to have it included. The defendant also argues that Pomplin intentionally misrepresented the relationship between the defendant and Aaron Imholt in the application. The defendant notes there was a pre-existing relationship between Nick and Aaron by referring to prior videos where they appeared together or Imholt appeared from Nick's house. Pomplin concluded there may have been a recent falling out between Aaron and Nick. He also indicated Aaron and April had separated. Pomplin informed the issuing magistrate, Judge Fisher, as she's sitting there squeezing liquor bottles with her vagina, apparently, according to Nick, that Aaron and Nick were no longer on good terms. The full-throated threats that Nick references in his memorandum all involve the idea that Aaron knows information about Nick that Nick doesn't want to be made public. And I think that's very true. This does not indicate something more than a falling out. The statements that Nick cites as threats are not threats to physically or financially harm Nick. They're statements about sharing secrets Nick doesn't want shared. Yeah, Mm-hmm. Detective Pomplin's statement there may have been a falling out between Aaron and Nick is not a material misrepresentation of the facts. And I would agree at this point because also remember, what did Nick's attorney say? What did Nick's attorney say in the transcript? They just don't like each other. Not they hate each other's guts or they'll fight if they run into each other. He said they just don't like each other. Is that really any different from having a falling out? No. You've conceded that point now. Which once again, I get it. You don't want to come into court and say, well, Your Honor, our coke-fueled fucking suck, this is going on here, and Aaron's mad because I stole his wife. And now she's it's a 3-person fucking suck instead of a 4-person fucking suck. Yeah, that's horrible. Like, bad. It's bad. It's embarrassing. But that's a lot more than they don't like each other. Now, I love this line. The defendant may disagree with it, but that does not make it a lie. Yes. Everybody I don't like is not Hitler. If I don't like you, you're Hitler. If I don't like you, you're lying. No, that's not how this works. The statement indicates there's no longer an ongoing relationship. A falling out indicates the ending of that relationship was not on good terms. Even if the statements the defendant cited as memorandum were included in the probable cause portion of the affidavit, there's still probable cause. The statements cited by Nick indicate that Aaron and Nick indicate that M. Holton, the defendant, and this is where a prior personal relationship is no longer ongoing. This is the same information provided by Pomplin. Pomplin gave the issuing magistrate additional information. Remember, the issuing magistrate is Judge Fisher. They call it a magistrate, but that's why they use the term magistrate. Magistrate also goes back to the Roman times as somebody. Yeah, and we're not going to go to that. The statements made by Aaron. Detective Pomplin notes that Aaron had personally used controlled substances in the recent past, and there were direct statements by Aaron that Nick was using controlled substances. Pomplin pointed out that Aaron insinuated use by the defendant, but did not directly state that. Aaron also talked about a video where Nick appeared to be under the influence. Yes, and as I said before, guys, Aaron's information coupled together with this, Aaron alluded that Nick had used controlled substances, and he admitted that he had used them himself. Aaron wasn't the sole basis for the search warrant. And the things Aaron said were reinforced through other information. Aaron had no idea about the Scandinavian prudes. Aaron had no hand in Nick making that video. So Aaron's information was corroborated. So, yes, even if you include all that, there's still probable cause. Yeah, Aaron and Nick hate each other, but what Aaron said, I could verify. Okay. The information provided by Aaron is not the sole base for the search warrant. Aaron's video on May 22nd refers to a video Nick produced the day before, where the defendant appeared to be under the influence of drugs. Pomplin did not rely on that statement alone. Pomplin then watched the defendant's video for himself. So yes, I understand Nick couldn't wrap his mind around reading the complaint, but that's what happened here. That's what happened. Nick read it, or Pomplin watched Aaron screaming and hollering, saw that clip and said, huh. And then what did Pomplin do? He then went and watched the full video. That's how this works. That's how this works. He did an investigation. So Nick ran around screaming, he lied, he lied. I just want him not to lie. It's not hard. He don't lie. No, Nick. It's very clear that he watched the 4-hour and 4-minute video. Why would he know it's 4 hours and 4 minutes? Because he watched it. Pomplin has been trained as a drug recognition expert. And I will say, yeah, drug recognition experts are generally bullshit. But when they can tell for sure, well, everybody can tell. But like drug recognition experts on DUI stops are a whole load of horse shit. I will say that much. I think I've said that before. But based on his review of the record, Pomplin determined that Nick was showing signs of being under the influence of a controlled substance. The defendant argues that Pomplin didn't watch the entire video that Nick published on his social media on May 21st. In support of that contention, he submitted a PowerPoint that contains a clip from that stream. The clip is less than 1 minute long and does not include any audio. This is a clip from the full video that Pomplin created. Now, this is where I know Nick is going to go run around screaming, see, he said created, Pomplin made it, he lied. No, Nick, that's not what he's trying to say. And no, you don't got him now. The walls are not closing in. You're not going to lead Pomplin out in handcuffs, buddy. Just, there you go. They point out the video, it was disclosed to the defense on July 3rd. Defense counsel downloaded it at 12:31 p.m. on July 3rd. Now, how do they know the specific time of this? Because there is software, and I have this here with a bunch of the counties I deal with, where they say, hey, here's your discovery. It's all electronic. Okay, so you download it, and it'll put on the screen with each file, last access this day. So they know when you've looked at it. And I can tell when you've looked at it. I can go back because I've had, when I was a prosecutor, we had a case once where the defense attorney said, oh, I never got this. I never saw this. And I went and opened it up and hit print. And we brought out the data and it says, look, it was closed to defense on July 23rd or July 3rd, and he downloaded 12:31. It's because you can pull up that metadata. And I can pull up that data. If I'm the prosecutor, I can pull it up and say, look, here's when he downloaded it. Now, is Nick's attorney going to claim that there's a conspiracy and they're lying about when this happened? No. John says, what will I talk about once this is over? Well, Nick, I'm probably going to talk about sandwiches a lot because I'm fat. It's almost like there's a song where I talk about like all the different shit I talk about. So anyway, what was also disclosed on July 3rd at the same time as the PowerPoint was the entire 4-hour and 4-minute long video from the defendant's channel with audio. This was downloaded by defense counsel on July 18th at 12:49 p.m. This full video has been uploaded for the court to review and shared with the defendant. Oh boy. Now let's go back to Nick's motion because this is fun. Here's Nick's motion where they're screaming and their panties are on fire about this 1-minute clip. Chat, it contains the watermarks. Chat, it contains a watermark. Chat, there's a watermark there. It's been altered. It's been edited. There's a watermark, chat. No! Screams Nick from the Baldo bunker. They lied. Why can't they just not lie? I just don't want them to lie, chat. The police lied. No. Well, sounds like someone else may have made an omission here. I mean, actually, I'll just say it sounds like someone's lying. Sounds like someone made an omission, an intentional omission of what's available. I mean, really. You're sitting here screaming and crying about this 1 little minute clip video, and you've got the 4-hour and 4-minute hog sitting behind you. Like, really? Yes, this should terrify you. What can happen? You mean the state handing over all their discovery? It should terrify you. You're focused on this piece of rock. And the boulder it came from is behind you. Like, this is flim-flam bullshit. This is flim-flam bullshit. Now, some of you might be saying, well, can't Nick in his reply go, ha-ha, that's what I wanted you to think, but here's my real argument. Not really. You're kind of like you're responding to the state's argument. Trying to introduce new evidence, a new argument at that point is not allowed generally. And if he tried, I'm sure the state would say, no, that's not fair to us because then we have to respond to that. You have to respond to everything we've already agreed to. And no, this isn't like some shitty card game where you just like play a card and you just slow play your way through it. Like you're playing Texas Hold'em and you're just checking the whole way through to the river. No, you got to fucking play your cards. Oh boy, Nick, this is not good look. The other problem is when you're trying to convince the court, Your Honor, they lied. We need a hearing. And you're fucking lying yourself. Or I'm sorry, you misrepresented or omitted something. Your Honor, why aren't you focused on the real things? You know, the judge isn't going to be fucking sympathetic to you. He's not going to trust you. That's not good. That's not good. That's not how this works. You can't do that. But let's move back to the prosecutor's motion. Now we're back on the prosecutor's motion. The defense argues on the PowerPoint clip was manipulated, but as you can see from the full video stream, the clip is taken directly from the video at approximately 2 hours, 50 minutes, and 40 seconds into the video. The only editing is to cut the clip from the entire video. The other brand on the clip may have been from the application used to make the clip. Remember, we don't know what it is because there's nothing included in the motions. There's no pictures or anything that's provided that's attached. The full video shows that is entirely from the defendant's channel, which will be interesting to see where he got it from. There are no other labels or markings indicate the video is not authentic. Now, here's the big thing, chat. At this point, that's good enough. This works. This is good enough. This is good enough to get probable cause. This is good enough. They don't have to have the entire provenance worked out or demonstrate everything about it. This is there. They've met probable cause. This isn't a Frank's issue. Yeah, it just doesn't work. Nick, I mean, holy shit, Nick. Dude. This is fucking garbage. Like I said, that JDAM I put on the screen is very apropos. She just dropped a fucking JDAM on your argument and just skadoosh. Like you're some Afghan guy on a fucking moped getting hit with a JDAM, dude. There ain't nothing left. Like, why would you do this? This is fucking sloppy work where the prosecutor can point out, they're fucking lying. Prosecutor, she pulled out a reverse card and said, no, you. That's not good. That's not good. Now, I understand Nick might also try to make an argument here that, oh, no, she doesn't understand what we're arguing. The prosecutor's too stupid to understand what we're arguing. Nick, if I can't figure it out, and most attorneys can't figure it out, the prosecutor can't figure it out, the judge isn't likely going to be able to figure it out. That doesn't mean you've got some super space brain 85 chess esoteric argument that, we just don't recognize today. No, it means your argument's fucking retarded. It means it's garbage. It means it doesn't fucking work. It just doesn't. And they point out, Detective Pomplin informed the issuing magistrate the video is no longer publicly available and he is able to view the entire video stream. Ooh, it sounds like he may have been able to get it. Now, does that sound like he had a sloppy affidavit? Sure. Is that not as correct there? I don't know. But was he lying? No, it doesn't appear he was lying. Now, am I going to believe that this prosecutor is lying? I get it, Nick. I dare you to call the prosecutor a liar. Let's see how well that goes. But at this point, they're calling you the fuck out. Are you telling me you haven't seen this video in Discovery? You guys really only had the 1 minute clip? I'm calling bullshit on that. I'm going to call bullshit on that, Nick. So, yeah. The entire video is consistent with the statements made by Aaron. Yep. And remember, that corroborates Aaron's information. Detective Pomplin used his own training as a DRE to describe the defendant's behavior and how that's consistent with drug use. Pomplin did not misrepresent the information. He viewed the entire video. This was disclosed to the defendant. The defendant had this video for over a month prior to the omnibus hearing. Instead of being candid with the court, remember, guys, as attorneys, we have a duty of candor. You have a duty of candor. And candor means being truthful, chat. You have a duty of candor to the court. You have to tell the truth. You have to be honest about things. You can't lie. You can't misrepresent things. You can't omit things intentionally. You can't lie by omission. You're allowed to mess up or get something wrong, but you have to fix it. You know, the defendant implied the only video that was closed to them was the short clip. And it's correct. When you read this, guys, go back and read this. In discovery, the state produced a PowerPoint presentation with what purports to be a clip of a defendant's May 21st, 2022 live video stream, as well as the image purporting to be a screenshot of the same. Now, I just realized this, but that Aaron, Nick, your attorney, he mistyped something. It wasn't 2022, it's 2024. Nick. Oh no, did your attorney lie? Is this perjury? He didn't get it right. Nick, he didn't get it right. No, this is perjury. Nick, your attorney's perjurious. We got him, chat. Like, yeah, there, Nick. It's like, see it once again, Nick. This is like player to player, pimp to pimp moment here. Okay. Do you listen to how retarded that argument sounds? Like, oh my God, they misspelled something. It's perjury. No. Quit trying to do this like you're some pro se litigant. Like, actually, you went to law school. Like, no, you did. Do it the right way, man. Come on. But they spend all their time talking about this goddamn clip. They spend all their time talking about this clip, chat. And what do? They don't talk about anything else. They talk about the applicant did not review the defendant's original video. This is a misrepresentation of material fact to the court. And they're just talking about all the bullshit here about what he viewed, when in reality, he fucking viewed the video. You know, that's the thing here. Like, Nick, you, like, how do you go from doing all the stuff you've done before? You know, you weren't a stupid guy before, but now this is just like how the mighty have fallen, and it's even more sad. Like, from where you were at the time, at the top of where you were, to this is, like I said before, this is like when you go to the bar and there's that barfly that sits at the end who's drunk all the time and gets in everybody's fucking way and goes and fucks with the jukebox and is trying to dance with everybody's girl, and then after a while kind of like sticks back up on a chair and then eventually gets so drunk he falls off and cracks his head open and then comes back tomorrow and does it all over again. It's like, it's sad. It's sad. Now, this is the prosecutor being very nice. She says this has the appearance of an intentional misrepresentation to the court of what information has been disclosed. That's her way of being very nice, saying, you guys are fucking liars. That's her nice way of saying it. That is a nice way of saying it. And yeah, basically, Nick and his attorney sound like fucking liars. And remember, you're trying to convince the court, Judge, we want the Franks hearing. Detective Pomplin lied. You know, what about you, Mr. White? It looks like you guys lied. And you're like, no, we didn't lie. Well, I mean, there you go. But yes, this is Kristen Pierce. You know, the girl, Nick's like, she's learning how to type. Nick, she came in and ate fucking Frank's lunch. She took her dick out and rubbed it on your face and said, do something about it. That's what she just did here. She called you the fuck out. So the question is, Nick, and for your attorney, are you guys going to take that? I mean, you're kind of going to have to, because you got caught. So you're going to have to take it. Just saying. Now, they talk more, though. Additionally, Pomplin viewed videos from Nick's channel going back several months. Between January and May of 2024, Pomplin notes the defendant's Changes in appearance, including that he lost weight, appears tired, and overall appears strung out. Yes. All of these are common with controlled substance users per Pomplin specialized training as a DRE, as experience as a cop. Well, it's also common with anybody who has experience with drug addicts. Nick failed to make the requisite heist, showing that the affiant, Pomplin, intentionally made a false statement or with reckless disregard for the truth. Therefore, the defendant is not entitled to a Franks hearing. Any challenge to the search warrant is limited to the four corners of the document at this point. The state requests an additional briefing schedule. The defendant is raising a general probable cause challenge to the warrant, which, they're probably going to have to do because they're going to lose the Franks hearing here. And if they lose the Franks hearing, okay, well, now you're challenging the general probable cause of the search warrant, and you're going to lose on that too, man. You're going to lose on that too. But we'll see. We'll see what happens. Is it, like I said, Chad, are we 100% guaranteed? No, but it's like, if I had to bet money, if I bet the money in my pocket, I'd be betting on this, the court ruling in favor of the state on this one. So we move on to the seizure of the firearms and whether it was lawful. The defendant's argument is grounded in the prohibition on reasonable searches and seizures. Yep, under the 4th Amendment and the 14th Amendment and the Minnesota Constitution. And they talk about, the right of people to be secure in their persons and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause. And they say, as a general rule, any search without a warrant is per se unreasonable unless the search falls within one of the few specifically established and well-delineated exceptions. And as well established under certain circumstances, items not named in a search warrant may be seized. The plain view exception to the particularity requirement, and before we get far, chat, remember, a search warrant, you have to talk about specifically with particularity where you're going and what you're looking for and what you think you're going to find and how you could find it and why do you think it's there. You have to have particularity about those things. You have to say exactly where you're going. And you have to be able to identify it. In this one we read, Detective Pomplin identified it by its address. But let's say it was an apartment. So you'd have to say, or it's a bunch of townhouses or row houses put together. You have to say, it's like 123 Elm Street, and it's a row house. And it's a third house from the end. It's got a green door and pink shutters on the first floor. And on the second floor, it's got black shutters. You're going to do as much as you can to specifically demonstrate that property and like the particularity of everything. So the particularity requirement there is also about what exactly you're looking for, because you can't just say we're looking for anything illegal. No, specifically what in relation to what crime. So the particularity requirement is satisfied where an officer lawfully executing a search warrant authorizing the seizure of certain items inadvertently comes upon other items whose nature is immediately apparent. And the police have probable cause to seize an object in plain view if the facts available to the officer would warrant a person of reasonable caution in the belief certain items may be useful as evidence of crime. To justify a warrantless seizure under the plain view, the probable cause must be based on evidence revealed in plain view and cannot be obtained after conducting some further search of the object. Now, in Nick's case, we're going to get to this. The search was for controlled substances. During that search, firearms were located. The exact models and locations are listed in Supplemental Report 1 submitted by the defense. The officers were acting within their legal authority to search the defendant's home pursuant to the warrant where they located the firearms. And remember, chat, this is the time where when you're looking for stuff, if I'm looking for drugs, I can look everywhere drugs will fit. Could drugs fit in, my business card holder? Yes. Could drugs fit in a lot of places? Sure. But let's say you're looking for a murder weapon. Could you check in this? No. So if I had a gram of coke in here and you couldn't open it and find it, and if you found it, this would be an illegal search because you weren't allowed to look in here. You shouldn't have been looking in here. But you can look anywhere in this room where you could hide. If you're looking for a knife, where could I hide a knife? Let's say it's a fixed blade knife with a 7-inch long blade and a 5-inch handle. Well, now you have to look for somewhere I can hide it that's a foot long. Anywhere in this room. Well, in Nick's situation, they're looking for drugs. Okay, well, we could find guns in those same spots. And you don't have to look at the gun anymore to know that it's a gun. And you also don't have to look anymore to know you can't have guns and drugs. That's a violation of state law. There is no limitation in the warrant that areas of Nick's home were not to be searched. And sometimes there may be limitations. There might be unique living circumstances. There might be other third parties there. There might be any number of reasons why warrants are limited to certain areas. The firearms were located in the bed, under the bed in the master bedroom, in the garage, and in a safe in the garage of the home. These locations were authorized by the initial search warrant. When law enforcement found the items, it was immediately apparent they were evidence of a crime. Remember, guys, when they pick them up, they go, these guns are contraband because you're not allowed to have drugs and guns. As I said before, that's how they did this. It's a very simple argument. In Minnesota, it's unlawful for a user of controlled substance to possess a gun. Also located in the home was over 26 grams of cocaine, 8 units of ketamine, and there was evidence of these controlled substances in the home. In the master bedroom, they located all the tubes that tested positive for cocaine, the container filled in the grinder that tested positive for cocaine, the bag of cards and the dollar bill that tested positive for cocaine, the scale that tested positive for cocaine, and the mental pan. Oh no, chat, she did it again. It's a mental pan. There's no such thing. She committed perjury, chat. Game over. I mean, seriously, Nick strikes me as like using these arguments. It's the bullshit arguments. They misspelled your name on the ticket, therefore it's valid. It's like, no, that's not how that fucking works. It doesn't work that way. It's over. Case closed. Nick is free. So the metal pan tested positive for cocaine. And they're probably freebasing out of. The metal cutters that tested positive for cocaine. The hundy that tested positive for cocaine. And the cocaine scooper. These items are direct use in the home in addition to actual controlled substance found. And Pomplin, as a trained DRE, had his own observations of the defendant from his videos that indicated being under the influence of drugs, as well as the statements of individuals from CPS who indicated there were concerns of ongoing substance use. All this information taken together shows there was evidence of controlled substance use. When the guns were found in the home, it was immediately apparent the firearms were evidence of a crime based on the controlled substance use. There was no further need to search the guns, and that's the point. You don't have to open up the guns. You don't have to check them. That would be a search. You don't have to run the serial numbers on them. Running the serial numbers on an item, that itself is a search. And I know Kurt and Nate had talked about it, I think, last night or the night before. There's a Supreme Court case where the police were in a guy's apartment, and they saw a stereo, and they're like, that looks like a stereo that's been stolen because we got to be on the lookout for the stereo that was stolen. And what did the police do? They walked up to the stereo, and they moved the stereo, and they turned, and they read the serial number on it. That's a search. And they didn't have a warrant for that. That search got suppressed. I forget the case off the top of my head, but that was actually a big one. So that's the issue there. You don't have to search anymore to figure out what's going on. The gun is the gun. Their possession is evidence of a crime, making it immediately apparent to law enforcement their evidentiary value. Accordingly, their seizure was lawful under the plain view exception of the warrant. And they say defendant's motion should be denied in their entirety. The defendant failed to make the requisite high showing that Pomplin made any material misrepresentations or omissions in the application. The defendant's argument relies heavily on their assertion Pomplin did not view the entire video of the defendant's reference in the search warrant application. This argument overlooks the fact the entire video was disclosed to the defendant at the same time as the clip his argument hinges on. The information provided by Pomplin was accurate and no material misrepresentations or omissions were made. The seizure of the firearms was legal under the plain view exception. The firearms were immediately recognized as evidence of crime because you can't use controlled substances and you're prohibited. As their evidentiary value is immediately recognized, their seizure is permitted under the plain view exception. Now, this is, I guess, a little weird here. Normally, you include at the bottom your prayer for relief. Wherefore, the state asks that the court overrule the defendant's motion to dismiss, motion to suppress, and also deny their Frank's motion as improper. So it's usually you put that here at the bottom, but it's not there. I don't know why it's not. So that's where we are with this. Nick got fucking BTFO'd here. I understand Nick's like, I wasn't blindsided. I'm like, if you weren't blindsided, you guys fucking set yourself up. Like, you set yourself up to get sucker punched. And I know why you would do that. You admit the fact that you have the 4-hour video in your possession and you aren't challenging that. I mean, if you have that, challenge that. But instead you're like fucking around with some little ancillary thing. Come on, man. Come on. That's fucking weak. That is fucking weak shit, man. That is not going to work. This was not good. And now seeing how shitty that motion was, and then seeing how poorly it was put together, and now seeing this, ooh, child. That is not good. That is not good. I am not impressed at this point. You're fucking running your mouth about this 1-minute video clip when you've got the whole goods behind you like that. Come on. Oh.